Okay, give you a minute to kind of walk through those permissions. So what I'm gonna try to get Dina on in just a minute, but so for those who don't know me, my name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice. We are a TTA provider under the Bureau of Justice Assistance grants for both the upholding rule of law, preventing wrongful convictions, and the post-conviction DNA. And this month we are thrilled to have Katie back with us again from North Carolina to talk about evidence collection and evidence search. We've gotten that question quite a bit from folks on DNA cases, and Katie is quite the expert on getting evidence. And she's going to tell you exactly where she's got. Unfortunately, I can't get the
It's so funny.
Get the poll everywhere to work, Katie. So we're probably just going to have people throw this into the chat. That's okay. But Katie has been with the commission in North Carolina since 2013. She's the one who is out there looking for that evidence, trying to find it when these requests come in. Do you remember from the last time that we were together, the commission in North Carolina has a just test it policy, where if a request comes in for DNA testing on the case that they think would be probative of guilt or innocence, they go ahead and try to test it. Well, before you can test it, you got to find it. And that's kind of what we're here to talk about today. So, whoops. Yeah, that's what I was afraid. Give me 1 second here. There we go. So I'm going to keep this in this view just because we are having trouble kind of getting into the poll everywhere. So please put in the chat for and consider those A, B, C, D, and E. Which of these locations is a real location where the North Carolina Innocence Inquiry Commission has found evidence? A, inside a diaper box. B, inside a break room refrigerator. C, inside a personal storage unit belonging to a former detective. D, inside a jail cell. Or E, I think they found it in each of those spots. And I'm going to hand over to Katie from here because you're going to take it from here. I'll just advance the slides that you have.
Okay.
Give me your Vanna.
I'm sorry. Do I need to share my screen? You're on mute, Melissa. I'm sorry, or Marissa.
If you have your own PowerPoint, happy to have you do it. Otherwise, I'll just run it myself. You let me know.
I can share my screen since I've got some notes typed for myself.
Fantastic. I'm going to stop.
Thank you.
But it looks like you weren't stealing anybody. Because so far, everybody says you have found evidence in all of those locations.
And they would be correct. Okay. Let me make sure I've got the right. Is that sharing my PowerPoint? Okay.
It's coming up.
All right. Okay, great. All right. Welcome back, everyone. Marissa said, my name is Katie Matoyan. I'm the Assistant Director of the North Carolina Innocence Inquiry Commission. Some of you attended my presentation a couple months ago about our philosophy on DNA testing earlier this year. I'm back today to talk about searching for evidence. Before we begin, I do have a few additional poll questions for you. You could put your answers in the chat. The first one is, who among us is searching for evidence in a case right now? And the second is, what happens to evidence entered at trial in your state? If you could put those answers in the chat, someone from my group is going to text me the answers so I can see them. And while you're doing that, I wanted to give our new executive director, who started since the last time I spoke to you all, Laura Piero, an opportunity to introduce herself at the beginning of this.
Good afternoon, everybody. Welcome. I am delighted to be here. I am the new executive director for the North Carolina Innocence Inquiry Commission. I'm super excited about being here today, most specifically to listen to our esteemed colleague, Katie Matoyan, give us this presentation. We're all very much into the evidence space and specifically the search. Katie is our leader in that regard. And so I invite you to sit back and relax and enjoy the presentation as we do on a daily basis and listening to Katie expound upon her wisdom here at the commission. And I thank you for giving me this opportunity.
Thank you, Laura. All right. So a quick outline of what I'm hoping to accomplish today. I want to kind of set the scene for evidence in North Carolina and how it's handled, and also how the commission approaches handling evidence, just so you have an idea of where I'm coming from with our approach to evidence. I recognize that the commission, I'm in a pretty unique position. I think there's lots of helpful principles, though, to take back to your cases. Then I want to go kind of deeper into our approach with some lessons learned and some case studies throughout the years. Then I want to end with plenty, and I mean plenty of time for questions and answers. I'd like to be as helpful as possible to anyone here. And as with my DNA testing presentation, I am available to you all as a resource after this, should any of you have kind of a stumbling block in a case or want to bounce some ideas off of me. I worked under our DNA grants for 9 years before being promoted. So I've done a lot of this. I'm really, I love looking at a case. I love thinking about what to do. So please keep me in mind. All righty. So last time I went into a bit more depth about the commission, so I won't go over a ton of that today, but just as a reminder, the commission is a neutral fact-finding state agency that investigates claims of innocence by people who've been convicted of crimes in North Carolina. We're outside the normal appeals process, and there is our staff investigation process, and then a two-part hearing process by which someone can be exonerated. We remain the only state agency of its kind in the country, though we do get interest from other states all the time. If you'd like to talk about starting a commission in your state, please reach out to us anytime. All right, so in North Carolina, the handling of evidence is governed by 15A 268. So I kind of want to start there. And I wanted to add in the policy behind preservation of evidence as enacted by our General Assembly. I believe this part in bold, identification, detection, and exclusion are facilitated by the analysis of biological evidence that is often left behind by the perpetrator or is recovered from the crime scene. This policy really recognized the importance of biological evidence in solving crimes, even in the post-conviction space. I think this policy is really important. And here are some of the provisions of 268, some features of the statute and the requirements for how long evidence needs to be preserved. You'll see for most of those serious felonies, death sentences or life without parole, that's until either the death or execution of the defendant. For any of these other serious felonies, if they went to a trial, it's during the period of their incarceration. So this is kind of the statute that governs how evidence is handled in North Carolina. Another feature of 268 is the requirement of an affidavit from an evidence custodian if the evidence cannot be located and there is no documentation of the destruction of that evidence. We frequently ask for these in our cases. I've had Adina create a QR code that should link you to a sample affidavit that you can save and modify for your needs in your state. Typically, when I'm working on one of these affidavits, I have some kind of initial conversation with the evidence custodian and talk through some of the questions. I customize the affidavit for them a little bit, but then send it to them with a lot of blank space so they can fill in most of the substance and I'm not putting words in their mouth. Then what I learned from that affidavit really informs how I want to move forward. I'll talk about physical searches throughout this presentation. And throughout the rest of the presentation, I'm going to kind of go through the affidavit. I've got some screenshots of it, some of those questions, and kind of explain why we've added those, why we think those are important. Has everyone had enough time to scan the QR code? If they need it, I can go back to it at the end. All right, to bring it back to the commission specifically, one of the things I mentioned in my first presentation about the commission is our broad statutory authority. Our statute allows the commission to use all aspects of civil and criminal procedure in its investigations. This includes search warrants. This includes motions for entry upon land in civil cases. Our statute also allows the commission to collect and subject evidence to testing. We keep 2 evidence custodians on staff and have our own evidence room at our building that has to comport with the requirements of 268, just like anybody else. I serve as one of our evidence custodians, and we have another on staff as well. We will either ask for that affidavit, depending on the information we get in there. We will also go and do an item by item physical search of the agency sometimes. If that affidavit or their other answers just aren't satisfactory, I can't get to a commission hearing and the commissioners ask me, did you look for evidence? And I say, yeah, I called them and they said they didn't have it. That's not the world that I live in. Sometimes agencies, when the prospect of a physical search is brought up, have kind of balked at that notion. And when we've indicated that we believe we have the statutory authority to do so and we'll move forward, we're usually able to work out some kind of consent situation that allows us to do what we need to do. Our statute also requires that we report any wrongdoing. This includes any violations of 268. There have been a few instances where evidence has either been maintained or destroyed not in accordance with the statute, and we've had to report that information. We also try to be a resource to agencies struggling with evidence management and connect them with other resources that can help them with their specific needs. I've gone to a lot of evidence trainings and listened to a lot of evidence custodians. They're overwhelmed with incoming evidence and unable to make time to either destroy old evidence that's able to be destroyed, or particularly with small agencies, it can be difficult to deal with past evidence when you have this influx of new evidence coming in. All right, so now that you have an idea of how evidence is handled in our state and by our agency, I wanted to kind of underscore the importance of all of this evidence searching to the commission. So in 29 cases, either the commission or an agency who had the case prior to the commission has requested evidence from an agency, whether it be law enforcement or the clerk, and was told that it could not be found, either by asking more questions leading to additional search by that agency's staff, or by doing an item by item search, the commission has later been able to locate physical evidence or files. So all the case studies I'm going to mention in this presentation come from those cases. What we've learned here really informs how we ask agencies for evidence in any case. You're never going to see a commission case, like I said, where we asked where the evidence was, they said they didn't have it, they don't have any documentation, and we just say okay and move on. So going by the numbers a little bit here, in 7 of those cases, those ultimately ended in exonerations of 12 individuals. Testing was a factor in most of those cases, though not necessarily dispositive. So that's 80% of our exonerations fit into this category of 29 cases. In 7 of those cases, the DNA testing, based on the evidence we found, confirmed that the convicted person committed the crime. As I mentioned in our first presentation, it's just as important for us to find innocence as it is to confirm guilt. This allows for the efficient administration of justice because the defendant can no longer file motions related to an innocence claim after the commission has done this testing. So in 10 of those cases, just about a third of them, an agency prior to the commission had looked at and was told that the evidence didn't exist. By using our statutory authority, we were able to go one step further and get kind of a final answer on that evidence. In 2 of those cases, MARs are motions for post-conviction DNA testing. I'm sorry, that's a motion for appropriate relief. Were denied based on the belief that the evidence no longer existed. So as you can see by all of this, finding evidence is vitally important to us for a whole host of reasons. Our unique position has made it so this is something we've just gotten really good at. As with all things, we learn new things all the time. We learn new questions to ask all the time. So it's kind of an ongoing thing. All right, so now on to kind of those lessons learned and some case studies. Where do you start with searching for evidence? We start with figuring out where the evidence should be. And a lot of that is file review. Property records, crime scene reports, lab reports, trial transcripts. Since the evidence in North Carolina entered at trial stays with the clerk for the most part, we look at the trial transcript to figure out what the law enforcement agency should have and what the clerk should have. You also have to kind of try and figure out some historical context for the various agencies you're dealing with and the state itself. Evidence handling and management has changed quite a bit over the past 20, 30 years. So you've got to keep that in mind and ask questions related to that as well. When we talk about evidence, we're really talking about 2 things. The evidence itself, which is what you would ultimately love to find because you want to do that testing and see what you fine there. But you're also talking about any documentation of its disposition. Evidence isn't always missing. Sometimes it is confirmed destroyed. It's great that you can get that answer. Also frustrating because if the evidence existed, you could do something with it. Both things are important to us. When we're reporting on our DNA grant, BJA makes us distinguish between the evidence that has been destroyed and the evidence that is missing. So starting here, I want to focus in on destruction orders and documentation of destruction. The biggest lesson that I can impart to you here is that you need to read everything presented to you as documentation of destruction or other disposition extremely thoroughly. And if the documentation does not have a clear list of the evidence that was to be destroyed, an actual destroyed date, and a signature, witness signature denoting the actual destruction, that is not going to be good enough for us. So to give you some examples.
I'm jumping in to say, can you delineate that just a little bit more? It sounds like you're looking for three things: the order, the acknowledgement of the order, and then a statement that the evidence was in fact destroyed. Am I saying that right?
Yes. So you will sometimes see that part of 268 requires some court orders for destruction in some instances. So sometimes you will see that someone has made a motion to a judge to destroy evidence. If a clerk does it, there is an exhibit list. That's a pretty standard form in North Carolina, and they will attach that list to their motion, and the judge signs off on that. That's what's to be destroyed. But and I'm going to go into it in a little bit more detail about why it's important, but you need to really look closely at that list and make sure, because sometimes they put the entire, they're destroying everything. Sometimes they're only destroying specific items. So you need to make sure that the motion or order is very clear about what they want to destroy. And then we have received destruction orders in some cases. We've looked at it, and there's a part at the bottom that says destroyed by on this date. And there's usually also a witness signature. Sometimes that's not filled out. So then we say, hey, will you go back and look, because this part wasn't filled out. And sure enough, they hadn't gotten to the actual destruction yet. So that's what I mean by looking. You want to look for the confirmation, not just the permission that you're able to destroy this, if that makes sense.
That does. Thank you. And I'm wondering if those have a different process in your state, your jurisdiction. If you have questions about, please feel free to put those in the chat. I'm sure Katie can address those, as well as any other questions. Feel free to put them in the chat. We'll be monitoring. Sorry to interrupt, Katie. Thank you.
No, you're fine. Thank you. Like I said, sometimes the clerk will seek an order for destruction using the exhibit list. You have to look at that very carefully. One of the 29 cases involved a signed court order for destruction, no signature confirming destruction. You need both. In one of our confirmed guilt cases, the claimant had filed a pro se post-conviction motion for DNA testing. The DA's response to the motion included a signed order for destruction of evidence and indicated that all the evidence in that case had been destroyed, and the judge denied the motion on that basis. We got the case 8-ish years later. We compared that order to the exhibit list from the trial and determined that the rape kit and the victim's and defendant's clothing was not included on the list labeled for destruction. So we called the clerk, and they were able to find that evidence within about 5 minutes. We DNA tested the rape kit and confirmed guilt. But you can imagine if that had gone the other way and the DNA testing had showed innocence, that person would have been in prison for 8 years longer than they needed to be because of a clerical error. So I will repeat again here, if it does not have a destroyed date, a destroyed by signature, you need to ask more questions. You need to make sure that those things are there. All right. Moving on to kind of facilities and history, you'll see here that I've cropped part of that affidavit. Something that's important for us to understand is the agency's facility and history. But first, I want to point out the phrase physically searched in paragraph 3 here. Whenever I call and ask for evidence and someone tells me they searched their computer or their system and they didn't have anything, I always request that they go physically look. I'll go into this in a bit more depth later, but this is because our experience with a lot of agencies, particularly smaller, more rural ones, where all the recent evidence coming in is barcoded and perfect and in their system the way it should be. And then they've got this massive old evidence from the old way of handling evidence that isn't included in their system yet. So one of the things we want to know is if the agency has moved in between the time of the case and the time that we're talking to them. If it has moved, how is that old building now used? Is it still a building related to any government agency? Was it sold? Is it now a private facility? We also want to know what the oldest piece of evidence they have. If your case is in 1985 and they tell you they've looked and they don't have any evidence in their system or facility prior to 1995, you can feel a little bit more comfortable about what they're telling you. Not 100% comfortable, but a little bit more comfortable. Something we'll also do sometimes is we'll find the old evidence custodians. We'll ask who was in charge of the evidence room at that time, do some people searches for them and find them. Like I said, evidence handling has really changed. We want to know how they would have usually handled the evidence at that time. Odds are they don't remember your case specifically, but we do a lot of asking about practices and procedures from, the time periods we're talking about. I had a case where some evidence was missing and there was no documentation of destruction. And I talked to someone at the agency who'd been there a long time. And they said, well, I would sometimes just take the evidence out into the field behind the sheriff's office and burn it. All right. Well, now I know that. So we also want to know how their facility is made up.
Wait. What? Did they keep a list? Did they have any kind of record keeping around that?
No.
I'm sorry, I'm a little speechless on that. Okay. Were you able to get any information about what was destroyed and what was kept? And how would you go even about that?
Sure, we did a physical search of that agency. We went through a bunch of Connex boxes out in the field behind that had a lot of old evidence. We went through a lot of boxes. We looked for paperwork. They didn't think he kept paperwork, but maybe he kept paperwork, and we just weren't able to find anything that told us what happened to that evidence. So we also want to know how an agency's facility is made up. Do they have large item storage like bikes or cars or things like that? But you still have to go check those things because sometimes they throw a cabinet out there that has something smaller in it. So you need to know that it's not there as well. So we want to know how their facility is made up so we can really get a picture of, is this a really small agency? They just have one room. They don't have the space for any large items. This is a really small contained space that they need to look at. So all of those things are really important for us when we're kind of evaluating whether or not we need to go into a physical search. Another line of questioning you need to go down is how different types of evidence are stored. So for example, in these 29 cases, we had 3 cases where latent prints were found in the investigative file rather than in the evidence room. They didn't consider latent fingerprints to be physical items of evidence at the time of those cases, and they would just stick them in the investigative case file. So this is why I sometimes ask our staff to go back to the agency, even though we've received a copy of the file, and look in the physical file themselves. One of these case studies I have here is the Willie Grimes exoneration. Prior to the case coming to the commission, there had been other searches for evidence and no one had been able to find it. We were able to locate latent prints from a banana peel in a case file. We ran those prints through APHIS and they ended up matching to an alternate suspect. So you have to you would never think, I wouldn't think today that latent fingerprints would be stored any different than any other item of physical evidence. That's today. That doesn't necessarily mean from the 1980s. All right, just a few more case studies here. So one of the answers from Adina's poll at the beginning was the personal storage facility. The diaper box was in the storage facility, so that was kind of a 2-for-1. So in this case, there was physical evidence missing. We went, again, you have to figure out the trail of the evidence. Sometimes we put together a chart. This is how everyone labeled the evidence. What did each person say that they did? So we went back, we followed the trail, and we saw that It was last returned from the state crime lab to the detective in charge of the case. They were no longer with the agency and lived out of state. We reached out to that detective directly and asked them to look, although they said, I wouldn't have kept any evidence. We asked them to look anyways. They ended up finding the evidence in their storage facility. They immediately called their prior agency, who went to go pick up the evidence and then turned that over to the commission. That claimant was named Nolly Brown, and he was ultimately exonerated as well. I talked about him a little bit in my last presentation. So something we like to do before we move towards a physical search, and maybe a good idea for you guys if you can get the agency to agree with it, is to try to have a meeting with their agency. I find that in-person meeting where you can ask the questions from this affidavit and really assess their answers can really inform if you need to go further. It also takes some of the pressure off of just asking for a search outright. And in one case, this also led to an exoneration. The evidence couldn't be found. During a meeting with that agency, through asking some questions, they were able to find the evidence. There was also a bonus find of a previously not turned over file taped to the back of a door from the crime scene. So we got that with the evidence as well. And going back into why digging into the history and context of the agencies you're dealing with is so important. In our state, we know that a long time ago, the crime lab used to hang on to extracts, cuttings, other byproducts of testing, even though they had sent the original items back to the agency. Over the past 20, 25 years, the crime lab wanted to get out of the evidence storage business and returned those items to agencies with an accompanying letter. So now when I review a crime lab file, I know I need to look for that letter and see if they had evidence returned to them more recently. And the reason that's important is it's one thing if an agency doesn't have an item from a 1990 case and they don't have any evidence that old. It's a bit of a different story if I can say, hey, the crime lab returned this to you 5 years ago. You should still have that. 268's been passed. It's now, part of that. So that just gives me an additional question to go back to that agency with. All right, I want to focus in and highlight another exoneration case. In this case, prior to the case coming to the commission, there was a court order for a search for evidence. Evidence was found on top of, I believe, a filing cabinet in the clerk's office, but some of the evidence in that case was still missing. We entered, not a formal agreement, but we had an agreement with the sheriff's office to go back in and conduct an item by item search of their facility. So during the first day of the search, the commission had located some padlocked lockers in the gun room and asked what was in them. They said no one had used those lockers in years. At our request, the padlocks were cut off and items from the case were located in the locker. This agency also had outdoor Connex boxes. You'll hear me say Connex boxes several times in this presentation. It's the reason why I recommend our staff have rubber shoes that can be hosed off. They're usually out, outside of the agency, not particularly well. There's no air conditioning in them, I'll say that. We searched each of those. We found additional evidence in there, additional files in there. We were told that someone had seen evidence in a room in the basement of the courthouse where they kept food for the guys in jail. We searched that room, and then someone else said, no, I was talking about another room in the basement. We searched that one too. So the whole time we're there, we keep asking questions. Is there anywhere else? Is there anywhere else? So we just kept searching. We found things throughout the week, and that claimant was exonerated in part due to DNA testing after spending 37 years in prison. All right, so to tie it back to the title of my presentation a bit, keep asking questions. The question I always say for the end when I'm dealing with an agency is what I call the secret room question. This came out of a search for a trial transcript in a case. I searched everywhere for it, the DA, the defense attorneys, the claimant, the original court reporter, the Court of Appeals. We could never find it. There were some real questions about what might have happened at the trial. We were able to recreate parts of the trial based on the defense attorney's notes and his closing argument drafts. That's obviously no substitute for the real thing. So that case ended up at a 3-judge panel. During that 3-judge panel, I testified about our search for the trial transcript. There happened to be a man in the room while I was testifying, and he said, hey, we cleaned out that old room during COVID, and I think the trial transcript wasn't there. So sure enough, they found the court reporter notes. The 3-judge panel was put on hold for about a month while a transcript was created. I will say shout out to that defense attorney and his note taking, because they were pretty correct to the trial transcript once we had the real thing. But anyways, now at the end, I always ask, is there a random room? Is there somewhere with a random assortment of items where you don't know what's in there? That's another situation where it can also be helpful to ask to speak to the person who has been at that agency the longest, because they might remember, hey, we used to keep some stuff in there in a way that somebody who's only been there for 5 years does it. All right, I'm going to change gears a little bit to the portion of the affidavit that discusses evidence organization and documentation. So this is really crucial to figure out when you're trying to determine what they've done to search for evidence. Like I said earlier, evidence handling has changed a lot. My experience with a lot of agencies is that resources allocated to evidence are an ongoing issue. What I typically find is that there's someone over evidence who is new and fresh and well-versed in best practices for evidence and has everything new coming in barcoded and organized and in their system. However, there can also be 3 trailers outside with evidence from Bob, who used to burn things out in the field, that hasn't been able to be integrated into the new system yet because they do not have the time or resources to do so because of the volume of current evidence coming in. So that's where we end up searching. You want to understand how they organize their evidence. Sometimes agencies will organize it by officer or detective name. Some will put cases on shelves in chronological order. Some just do it based on where it'll fit in the facility. So going back to that week-long search, we found evidence and files for that case in boxes labeled with the lead detective's name. In another case, we also had received a destruction order that was a bit vague. So we asked to go in and do a search. That agency was very small and they just had boxes labeled with officer names, and all of the evidence for their cases went in those boxes. They told us, don't worry, we've searched the box for your detective's name and it's not in there. We opened the box and it was right on top. So you have to know how they're organizing their evidence. All right. My next big case study, I like to call this the case of the old jail cell. So this was an agency we had dealt with previously. They had always provided affidavits to us indicating all evidence in their custody was in their system, barcoded and searched, and none was found. So an old coworker of mine had just received an affidavit from this agency about a month earlier. I called about another case and there had been some turnover in the evidence room. So I was talking to someone new. When I was talking to them, I said, is there anything in your evidence room not currently in your barcode system? And they said, yes. This was new information to us because otherwise the previous affidavits would not have been good enough. It turned out there was an old jail cell filled with over 1,000 items of evidence that were not entered into the agency's current system. What happened there was that particular jurisdiction used to have a joint agency that kept evidence, did some crime scene stuff. When that agency was disbanded, instead of returning items to their respective agencies, all of it just went into this old jail cell. So the commission conducted 2 inventories of all of this evidence. We didn't find evidence related to the case we started searching for, but we did find evidence in a closed commission case. That evidence wasn't ultimately dispositive, but we found it nonetheless. So this is why when I say to keep asking questions, even if you talk to an agency a bunch of times, you'd rather be annoying than miss something. Right. Another important part of the affidavit is the part about inventories and audits. You should be able, I would imagine, to obtain a copy of department policies for evidence handling. I can't imagine that's not public record. Ask if they do internal or external audits. For example, clerks in North Carolina can be audited by the Administrative Office of the Courts. I'm audited by the Administrative Office of the Courts every year. And one of the things they look at is evidence handling and risks there. So copies of those are public record here. So you can request those and see if there have been any documented issues of evidence handling. I want to just distinguish here between audits and inventories. Audits are kind of a spot check. Inventory is a full accounting of what is in the evidence room. We do one every year. Something I want to throw out there is to determine if your state has a property and evidence association. We have here the North Carolina Association of Property and Evidence. I'm a member or other evidence custodian is a member, these can be a fantastic resource for you, as well as help with some of those history and context questions that you just may not be able to find so easily because you're not in the same position as the commission. Their director is a great resource. I have agencies call me probably once a month and ask for guidance or help, and they're always willing to help out. So see if your particular state has any kind of association like that that may be a resource to you. All right, we're almost at the end. Like I said, I wanted to leave plenty of time for questions, but just a quick summary slide of a lot of the things I've talked to you about so you can have it in one place. This presentation is about evidence searching, but I did want to end with just a quick note on found evidence that you intend to send for some kind of analysis and kind of tie it back to the first presentation. So once you've actually found it, you want to make sure there's some kind of documentation of how it has been stored in its current condition. So for example, a lot of times, particularly in older cases, evidence that is open and shown to the jury is not resealed when stored with the clerk after trial. Sometimes the items are intermingled. We had a case where we had intended to DNA test a pair of the defendant's shoes to determine if any DNA belonging to the victim was on the shoes based on the description we had of the crime. The shoes we found were unsealed and commingled in a box with the victim's clothing. So that made any DNA testing we were planning to do irrelevant. So how the evidence is stored doesn't necessarily always mean you can't test. However, you have to keep that in mind when you're determining what DNA test results, like what those results mean. So another example goes back to one of those 29 cases. We were told by a clerk that they didn't have any exhibits left. Then that clerk determined that 2 pieces of fabric were located in a box associated with the case, unbagged. We were able to, by this description of it and trial transcript and police files, determine that those were exhibits based on descriptions, that we'd received. However, we knew the items had been left open in a box for however many years, could have been previously commingled with other exhibits. And we also knew the clerk touched the items with his bare hands when finding them. And also when we went to go collect it and were trying to take it from him. So we have to keep these things in mind when we're DNA testing. That goes back to one of the things I talked about previously with all the elimination standards that you need to get. So when in doubt, document. When in doubt, keep asking questions. Again, you would rather be annoying than miss something. All right. And then I'm going to leave it open now for any questions that anyone may have.
So first,
Thank you so much.
so much for all. Oh, Adina's here. I'm sorry. Adina, I yield to you.
All right, Marissa, thank you so much. I apologize for not being here at the start. I had a little bit of technical difficulty. So we have lots of time for Q&A, so we'll do that in 2 ways. You can put your question into the chat, and then I will read it aloud to Katie for the purposes of our recording, or you can raise your hand and I'll recognize you and you can ask your question aloud. So I'm looking at the chat here and also trying to keep track of who's here in the room with us. So I'll ask the first question. Katie, was there a particular case that was a threshold for you where you realized that people had to be more diligent and dig deeper when looking for evidence? Is there something that tipped it for you?
For me personally, I think the commission had some experiences, obviously prior to me coming on, that kind of started our general process. But for me personally, it was that old jail cell case. I had gotten affidavits from that agency before. I thought that they were thorough. I thought that everything seemed above board. It was a larger agency, which you would think would tend to usually have, a little bit, their stuff together a little bit more, is having more resources. And so that was kind of my moment where I was like, well, I'll keep getting affidavits, but I don't know that I trust anything anyone ever says again. So that's just kind of an ongoing thing in my mind, really a balancing of what makes sense.
Thank you for that. We've got a question in the chat here that I'll pose to you. So Somebody asks, let's talk about hairs. I have a case from the 1990s where there was supposedly one hair in an evidence envelope. We got the envelope, but no hair is inside. I don't know if the hair disintegrated over time, went missing, or something else. Any thoughts on how to proceed?
Sure. I'll start with something that I forgot to say in my last presentation, I think, but sometimes when we're sitting around talking about what we should test and how we should test, we like to say, it's probably a long shot, but we're in the business of long shots. We had a case where we thought that it was possible that there had been such a struggle. We thought it was possible that the suspect may have been bleeding at the scene. There was what appeared to be blood on the outside of the door that was scraped off into an envelope. Some testing had been done before. By the time it came to us, that envelope was completely empty. We had them just swab and test the inside of the envelope. Because I don't think we ultimately ended up getting a very strong profile off it or even a usable one. But if something with DNA on it was in the envelope, even if it's not there anymore, maybe some DNA is still there. So I would say for your hair, hairs can go missing really easily, especially if things aren't sealed properly. I would probably, if that was a commission case and I still had the inner envelope, I would probably just send it for DNA testing and see.
Great, Katie. Thank you. That also ties to something that we've talked about in other TTA training and have talked about with regard to DNA testing is that one of the things that you can do is test the container or the packaging that the evidence was inside. So for those little evidence bags, especially for things that might have been damp, things that might have had fluid on them, you might have some transfer. So that's a great recommendation. So we've got, let's see, more time for questions. And I'll see if anyone has their hand raised before I move on. You're also welcome to drop your questions in the chat. I'm also interested to know, while we have everyone here, Katie, you talked to us about the strangest places that you found evidence, and I'm sad that I missed that poll because I think most people would have guessed all of the above. And I'm interested to know, folks in the room, what is the strangest place that you have located evidence, or the strangest place that you have searched for evidence? And if you can just drop that in the chat. Strangest place you have found evidence, or the strangest place you have searched for evidence, and we'll learn a little bit from each other. I'm just monitoring a little bit more here. All right, so we have a response. The weirdest place found evidence: back unused room in a police station that had been closed. So this is a trend of places that people say are not in use that are actually in use. Katie, I'm interested to know more about places you found evidence that are repurposed spaces. Have you found that evidence has been moved from the primary place it was put to some overflow location? Is that a common practice?
I think it can depend on the agency. Typically, it's it's a smaller town. They had their old police department that was a really small building downtown. They're now a little bit outside of downtown in a nicer, newer building. But again, that history and context is important. We'll go back and say, well, what did that evidence room in your old one look like? If I know in this case that they had a comforter, they had all these large items of evidence, and that old room was a closet, then did that make it over to the new place? Had they even been able to keep it? I would say some agencies have, documentation of those moves. It's just something, it's not as common to find things in an old building. It's just a question we ask just because we want to make sure. A lot of our questions are, have you thought about this? Can you go back to your old room and see if you have anything? So not so much common as it is like, let's just check this off the box and make sure we haven't missed anything.
Thank you. We've got some responses here in the chat, places people have found evidence. We've got a couple people finding evidence in personal storage of folks tied to the case. So we'll come back to that in a second. We've got a couple more questions here. Katie, this question to you from the chat. Do you get pushback from the evidence holding agencies or prosecutors or judges when you conduct searches for evidence? and how do you navigate that access? I know you're in a unique position at the commission.
Yeah, we navigate that all the time. I do find, sometimes that first initial question and then us asking more questions, when you start asking more questions, that's when the pushback starts. In general, we just try to keep it very factual. And that's when I try to schedule that meeting, say, hey, can I just come and talk to you for a second? I just want to be able to explain to you kind of where I'm coming from. And usually what the end result is once it's been made clear, we are looking for evidence in a case. You do not have it. You are supposed to have it. And you do not have any documentation of what happened to it. At that point, usually an agency really begins to understand, like, hey, it's important that I've done everything I can, to make sure that they've done everything they can. Because ultimately, if it goes forward, if it goes to a commission hearing, all of that information is going to get out. And so usually, like I said, even if we've initially had to say, hey, I understand that you don't want to allow us to come in and do a search, but we believe we have the statutory authority, we're going to go forward with this. Usually at that point, we're able to come to some kind of compromise and agreement. We have a list of guidelines for our search that we send out, so they understand I'm not just coming in to like paw miscellaneously at your evidence. I'm coming in with a plan, organized. I want to do my best to maintain your chain of custody. So there's always, pushback, but usually we're able to kind of move past that just by explaining our position.
Katie, it sounds like what you're saying is that by providing more information and making the process that you're going through a little bit more transparent, it opens up access for you.
Mm-hmm.
So we have a question here in the chat, a little bit more specific. We have a question about your banana peel case that you talked about. So we'd like to know, was that the original fingerprint that was found by the analyst in the 80s at the time of the case, or did the commission lift a 40-year-old print off banana peel?
I believe that was the latent lift that was collected previously.
It would have been cool, though. It would have been an interesting forensic situation. We have another question here. Katie, we're going to talk about destruction orders for a minute. Can you talk about whether a destruction order is something common to all agencies, or is that a state-specific thing?
So I don't really know outside of North Carolina how common it is. I know a lot of times when I go to police departments or clerk's offices, especially like a small sheriff's department, they usually have kind of a shelf. Here's all the things that we want to destroy that within 268 it says we can destroy. They've gone to the judge, gotten the judge's permission, and it's just waiting to be destroyed. So I'm not sure if that is common in other states. I haven't really done kind of like a literature review of other states' evidence handling practices, but I'd be interested to know.
For that answer, we've got another question here. So this question is says, in regards to receiving a response from, just clarifying here, give me a moment.
I'll just jump in. That's what page enough. In regards to receiving a response that the evidence is destroyed from a facility that is moved, there's a possibility the evidence is there but misplaced and not misplaced, right? So like, and this is something that we saw in Philadelphia a bit, where they would say, oh yeah, we don't have it, but it was like on the wrong shelf or in the wrong room.
Correct.
Have you seen those situations, and how do you?
Right. And that's why I mentioned earlier, we always have in the affidavit the request that they go physically look throughout their entire evidence room, because sometimes things do get put on the wrong shelf, or again, maybe it's old, now your organization is new. A lot of agencies, since the law related to untested rape kits a couple years ago, they now keep rape kits in one section altogether, even separate from other evidence in the case. So if that wasn't the case at the time, so now you need to make sure you're looking all those places. So that's one of the reasons why we always ask people to physically look rather than just open, open their computer and look. If someone called the commission and said, hey, I'm looking for a file you had in one of our cases, I pulled it up on our K drive and I couldn't find the file, I wouldn't just say, well, hey, I don't have it. I'm going to go to our file room. I'm going to go to archives. I'm going to double check and make sure that it isn't somewhere it isn't supposed to be.
And and I apologize if I missed this again. Connection's not great here. Train station. Are you physically going in and doing those searches yourself? And if you don't have faith that they're being conducted?
Yes. So like I said, it's either just kind of, there are some agencies we've had some past history with, and we know, hey, I need to come in and look just off the jump. Or sometimes I get that affidavit and I feel like it's kind of vague, and I go meet with them, and and then I always come back and talk to my executive director and say, hey, we need to go and do a search. At that point, we put together our evidence search procedures, send it to them with the request and say, this is how we'd like to do it. We're usually able to work out an agreement with that, or even just a couple times we've said we're going to go do a search. We end up just kind of doing a tour of the evidence room, and we're able to really see, hey, everything is barcoded. Everything is, you can spot check. Everything is where it should be. Here's where you keep your homicide cases, things like that. But yes, I have lifted the box off of the mummified rat that has been crushed for 20 years.
Put on the hazmat suit and go right in. But kind of unrelated to that, there's a question about pushback. So, obviously you're an agency responsible judiciary. Do you get pushback from either the local agencies where the evidence may be stored, or even the prosecutors in the local agencies who may not want it tested? And if so, how do you navigate?
Sorry, we're cutting in and out, Marissa. Are you saying if a prosecutor wouldn't want us to test evidence?
Yeah, like how do you deal with pushback either from the agency that may be storing it, or even from a local prosecutor who doesn't want it tested?
So that's where my statute comes in handy. So like I said, if anyone would like to start a commission in their state, please reach out to us. Ultimately, our statute explicitly gives us the ability to collect and subject evidence to testing. We do not need approval from district attorneys. But ultimately, I mean, we've never had a district attorney tell us we, shouldn't test in a case or try to block our ability under the statute. Usually, we're also able to get to a place with the district attorney where it's like, hey, this is our investigation. There's a question. We just want to test, and then we'll go from there.
Thanks, Katie. One of the things that we've talked about is how North Carolina is unique in having this commission and having the access that you do. Can you talk a little bit to what the climate was like when the law was passed, when the commission was created, the confluence of events that went into ending up with this kind of law, and what advice you might give to other people who were hoping to have similar laws in their states?
Sure. The commission kind of came about. There had been a lot of high profile exonerations in the state of North Carolina. So a former Chief Justice, I. Beverly Lake, had convened this actual Innocence Commission, a study group to kind of look at those causes of wrongful conviction and make some recommendations. The commission ended up coming out of that. That was the start of a lot of other laws that the commission, or that the state of North Carolina has, such as open file discovery, recording of interrogations, eyewitness procedures, things like that. So it kind of came out of, our preamble says that the purpose of the commission is to ensure that the innocent as well as the guilty receive justice. They wanted to build public confidence in the justice system, and recognized that creating this procedure for addressing wrongful convictions was really important to that.
Thanks for that answer. One of the things about doing this kind of work is it's a long slog, and sometimes you have to tell folks that you can't find their evidence, but sometimes you get to tell folks that you have found their evidence. So has there been a time in your career or in the career of your colleagues where you've gotten to make that phone call or tell that applicant that you've located physical evidence or something that you thought wouldn't be found was indeed found?
So since we're a neutral agency and we don't enter into that attorney-client relationship with the claimants, it's typically not the case that we would be calling, the claimant in prison, letting them know, hey, we found this evidence. Usually when they find that information out is either, we've let their attorneys know and they tell them, or the case is going to hearing and they get kind of the rundown of why it's going to hearing. And that's usually when they find out. So I'm usually not a part of that.
And that neutrality is something that I think we talk about each time we talk about the commission is that the goal is to find the facts.
Mm-hmm.
Let's see, we have another question here. Can you share a template for a search plan?
Yeah, I will. Once I get off here, I'll find an old one and take away any identifying information, and then I'll send it to Adina and she can send it out.
That's great. I can send it out to the list of attendees. We have one more question here regarding the commission itself. Have there been any efforts to cut back on the authority of the commission, to cut its budget, or has there been any pushback in the time between when the commission was created and now?
Sure. There's always, we have a presence down at the General Assembly. There are always other parties who have tried to make changes to our statute. Typically, if it doesn't threaten the neutrality of the commission or anything like that, we'll usually work out some kind of compromise. So, this work is this work, and sometimes there's always going to be people who have things to say, and that's fine. We try to take those on board. We really feel that we're a fantastic model. We're doing great work here. And we have usually been able to work out something every time. So we were lucky enough a couple years ago to get a major expansion to our budget, just based on how much we've grown, how many cases we're handling, things like that. So the General Assembly, we've always enjoyed bipartisan support since the founding of the commission. And that continues to this day. So we've seen that recognition from the General Assembly and really appreciate it.
So I'll encourage folks to get their questions in. We have a few more minutes for questions here. And I'm just going to go back in the chat and share a few more of our answers of where folks in the room have located evidence. Let's see. One person has said they found evidence in
I have a lot of questions about the hospital pathologist.
The hospital pathologist. Let's see. Would the person who had the hospital pathologist personal kit like to share? You can unmute yourself if you'd like to share that experience.
Yeah, it's quite a story. It's actually my very. Can you hear me? Can everyone hear me?
I can't hear you that well.
Nope, unfortunately not. Might just
That
drop
any
in
better?
the chat.
That any
Some
better?
other that is better. Thank you. Go ahead. Our friend in the room, please go ahead and tell us about your rape kit.
Can you hear me now?
Yes, we can.
Okay. So there was a hospital pathologist by the name of Rudiger Breitnecker who died a few years ago, and he had overseen the operation of the sexual assault program at this particular hospital in Baltimore County. What was not widely understood was he would take samples and he made microscopic slides, and he was very meticulous, and he did it correctly. I don't know if any of you have had experience with this, but if you don't make a slide correctly, you can very easily destroy the evidence.
Hi, happy birthday.
And so he maintained this every single case. where they had found any sperm. He had made these slides and he kept them in a section of the hospital lab. And because this was not widely known, it was really a complete long shot, but I called the pathology department because I had a pathology number from the hospital, and they found the evidence, and actually the evidence was tested and the client was exonerated. And then there was this huge hue and cry because the police, of course, kept saying, no, the evidence that, it's all been destroyed. The evidence doesn't exist. The police got very angry with the hospital. And ultimately, it turned into this big hullabaloo because there's literally thousands of these kits, which it's become a subject now in the legislature, because now there are calls for all of these things to be tested. And I think ultimately they were turned over to the police department.
Thank you for that.
Thank you.
There's probably a whole wealth of fascinating evidence search stories in this room. Just looking at the chat, we had so many interesting submissions. So we're here near the end of our talk. I just want to highlight, Katie's put up her contact information. This is the second of 2 talks regarding her work with the commission. The first is archived at convictionreview.net, where this will also be archived, and where all of these offerings continue to be available. While you are here with us, we'd like you to answer just a few poll questions that I'm going to launch now and should be available on your screen. And finally, I didn't get to introduce myself at the top. I'm Adina Thompson with the Quattrone Center. My role is training and technical assistance for folks who have post-conviction DNA grants. So that is presenting talks like these, and that's also helping folks who have DNA money work with experts who can evaluate previous DNA testing in cases or give suggestions for new testing, either on evidence that's never been tested before or retesting on evidence that's been subjected to prior rounds of testing. So that's what the post-conviction DNA, TTA, does here at Quattrone. And I know a lot of folks were also participating in the RTI BJA Forensics Conference that was Monday and Tuesday of this week. And I hope people had a great experience there. Those are also archived recordings. So all of these presentations through the Quattrone Center continue to be available after these live sessions. And as always, if you have any questions for us, if you need an expert or you need any help, we are here for you. So with that, I'm going to end the poll.
Hello.
And Katie, do you have any last
Hello.
comments?
No, just again, I had my email up there. If anyone ever has any questions or a tough case you're thinking about, I'm happy to be a resource to you. Please feel free to reach out to me anytime. Thank you for having me again. I hope you're all not entirely sick of me, but this has been really great. Thank you.
Thank you all for your time. We'll see you next month. Same day of the month and time. We appreciate your spending the time with us. Have a great day.